Go.
Good afternoon, everyone. My name is Muck Anderson, aka Muck Shit, better known as the little rascal that ran the judge out of the courtroom. And if you would like to schedule a live interview with me, locate me by downloading the Securus mobile app and searching my jail identification number, X0390-673, under the video visitation section of the application. Now, before we proceed, I would like to start by stating that I am an ex-convicted felon, and I do not have a high school diploma nor a college education. On the contrary, due to the presumption of incompetence that was placed upon us all at the time of our conception, I do not expect any of you all to understand the language of law that I am presenting in this matter. Now, Ms. J, you're free to ask me whatever questions you would like to know about my false imprisonment.
Okay, I got 4 questions all together. The first one is, describe in your own words the injuries you have endured due to your false imprisonment.
Well, my false imprisonment has been apprehensive and ultimately prejudiced on the grounds of me losing close loved ones, such as my father and most recently my grandmother, after the time clock for the declaration of a mistrial ran out and can be Googled under 18 U.S.C. 3161 subsection E. So, basically, the state had no longer than 6 months to retry me after the mistrial was declared due to prosecutorial and judicial misconduct. That 7 months after the mistrial, I was supposed to be getting discharged and acquitted of all criminal charges, but I wasn't. I'm still being falsely imprisoned under color of legal process in accordance with OCGA 16-5-42. But you want to know what did after that 7 months after the mistrial was declared due to prosecutorial misconduct and judicial misconduct? I lost my fucking father. Next question.
Well, sorry for the loss for your grandmother, by the way. What facts do you have that prove the public officers of DeKalb County Superior Court have violated your rights on the day of February 9th, 2022, governing your jury trial?
I have multitudes of material facts that can validate the implications of what took place February 9, 2022 in my jury trial. Strictly speaking on, in the pending case of the state of Georgia versus Deontay David, indictment number 21CR2124, February 14th, 2023 for a hearing, where Deontay David went before the Honorable Division I Hanging Judge Courtney Lynn Johnson of the DeKalb County Superior Court, and was duly sworn under oath and subject to penalty of perjury in accordance with OCGA 16-10-70 and 16-10-71 in front of other government officials. He declared that she aided and abetted with the assistant district attorney named Joanna Steiner LSP in an attempt to frame me, DeMonte Dontrell Anderson, aka Muck Shit, better known as that little rascal that ran the judge out of the courtroom, by conspiratorially targeting me as a gang member, by implementing an illegally subpoenaed false witness named Melissa Denise Jordan, using subordination of perjury in accordance with OCGA 16-10-72 and OCGA 16-10-93. The Honorable Hanging Judge Courtney Lynn Johnson voluntarily disqualified herself from Deontay Davis' case that day for reasons unknown, without holding him in contempt or penalizing him with perjury. With that being said, why the fuck am I still being falsely imprisoned under color of legal process in accordance with OCGA 16-5-42 by several persons pursuant to OCGA 51-7-22? Now, on Wednesday, July 10th, 2024, the Atlanta Journal-Constitution exhibited an article on crime and public safety, itemizing the YSL RICO trial. Within its context, Young Thug's lead attorney Brian Hill explained However, let justice be done, though the heavens fall. Actually, the heavens would not fall by unmasking bias and unethical members of the bar. On the contrary, Georgia Code 35-10-1 displays the language of the Code of Ethics for state government service members that is supposed to be conformed to by those duly sworn under it. In my case, said government service members loathsomely disregarded the ethics to their own well-being in lieu of the public's. Prior to Brian Steele's Malay against 40 counties governmental misconduct, on Sunday, June 23, 2024, the Atlanta Journal-Constitution referenced a quote from Atlanta Tea Party activist Debbie Dooley, stating that the judicial system is being weaponized, and if they're doing the ex-president of the United States this way, then we're next. The NAACP President Gerald Riggs and his law firm has reached out to me and DLA David to converse with us about our cases, in which we stated to them the application of law we needed implemented into our cases. We provided them with confirmation of the illegal activity being conducted by a citizen of the DeKalb County District Attorney Sheriff Boston office, such as illegally filed indictments and other legal instruments. Mr. Griggs and his law office failed to uphold the language outlined in the attorney's oath and the relevant Georgia Code 45-10-1, precisely Section 2 and Section 9. You hear what I said, Sergeant Nix? Section 9. Next question.
Explain in your own words what happened during your September 5th, 2023 motion hearing.
My 2023 motion hearing. September 5th, 2023 motion hearing. The DeKalb County state government made it transparent that they spend governmental funding on retired judicial officers to sit by designation and violate the constitutional rights of those that could potentially present themselves and properly argue the law respectively without legal counsel. Me properly exercising my First Amendment had caused me to receive a volatile threat of being gagged by the Honorable Judge sitting by designation named David B. Irwin in my September 5th, 2023 motion hearing. So he literally stand up out of his seat, leaned over the bench and pointed his finger at me like this and said, "I will gag you for reasons unknown." Brutally violating his oath of public officer, OCGA 16-10-1. Next question.
What does the context of the Supreme Court case of Hagan versus Levine in the year 1974 entail? Also, have you applied this legal authority into your due process? If so, how?
Okay. You see, a defendant such as myself inquires into the body of law. For example, common law, admiralty, and equity, that the court for which he is before is legally governing. And the federal question implemented into a state court proceeding compels the plaintiff to surrender the body of law it is challenged upon by the defendant. So basically, once the jurisdiction is challenged, it must be proven by the plaintiff. Hagan versus Levine, 1974. That statement alone is what caused the Honorable David Irwin to abandon the court proceeding at my September 5th, 2023 motion hearing. Or should I say, run the fuck out of the courtroom. After he brutally violated his oath of a judge. I mean, so basically I've been sitting here well over 2 years after the mistrial. They had 6 months to retry me after the mistrial was caused by the state trying to frame me. You know, they had 6 months to retry me. I've been here well over 2 years after that mistrial. I'm still sitting. No court date. I get to meet my assigned judicial officer. I haven't went before an assigned judicial officer since the the Honorable Hanging Judge Courtney Lynn Johnson voluntarily recused herself from my case December 5th, 2022. I do have an assigned governor appointed judicial officer by the name of Brian D. Lake. Let me read this letter that I wrote to my assigned judicial officer for the record. To my assigned Division 9 governor appointed judicial officer Brian D. Lake. It was filed on the record in the DeKalb County Superior Court Clerk Office, April 29, 2024. It states, I just thought you should know that your blatant discrimination towards me has exhibited malice and proves the cruel and unusual punishment you are intending to inflict upon me beyond a reasonable doubt, and brutally violates your oath of a judge, OCGA 15-6-6, like the proven and competent judicial officer sitting by designation named David B. Irwin did in my September 5th, 2023 motion hearing. Your Division 9 calendar clerk, Ms. Davis, has pointed the finger directly at you for being the reason she has not given me a court date, in which she has stated on multiple phone calls with my mother. With all due respect, this I'm told to the judge now. With all due respect, you ought to be ashamed of yourself, Mr. Lake, disgracing Governor Kemp's decision to appoint you. I truly believe that Governor Brian Kemp did not appoint you to be my assigned judicial officer to continue this mockery of justice. You haven't even been sworn in as a judge a whole year yet, and you've already violated your oath. Shame on you. With that being said, instruct your Division 9 calendar clerk, Ms. Davis, to schedule me a court date as soon as possible so I can be released for this burdensome false imprisonment. Because you and I both know that under the language outlined within 18 U.S.C. 3161 subsection E, as a federal statute, my illegally constituted indictment number 19 CR 2976 cannot be retried. And secondly, my indictment number 21 CR 1475 is proven invalid under the context indicated in Zugar verse 8. So why are you continuing to sandbag the due course of law? That's the letter that I wrote to my Division 9 assigned governor appointed judicial officer, Brian E. Leak, which is the governor of the state of Georgia, Governor Brian Kemp's defense attorney, or former defense attorney. And I wrote Governor Kemp a letter too. It was filed on June 13, 2024, in the Superior Court, Clerk Office of the DeKalb County Superior Court. It states, Dear Mr. Kemp, I'm writing you to inform you that Brian E. Lake has placed your decision to appoint him in question. The police can respectfully concur due to the fact that I have yet to meet him. It can be proven beyond a reasonable doubt that he had ample enough opportunity to conform to the laws of this state and for the United States of America by simply following the due course of law. Him being your former defense attorney under the ethics of the Georgia Rules of Professional Conduct contradicts the manner of which he is conducting himself under the Georgia Rules of Judicial Conduct. By simply disregarding his oath and knowing that I have been
Keep going, I'll be right back.
restrained of my
He wants to jump and I told him no. And then he hit his hand on the side of the bed.
the common law statute 15-6-6, Brian Elect supposed to be upholding his horrendous displays hold on. His horrendous display of adjudication resembles the language outlined within OCGA 16-10-1. I have yet to receive a response from Governor Brian Elect. I'm just still waiting. I'm still being falsely imprisoned under color legal process being kidnapped. You know, I just watch my family bury my grandmother. My family just buried my grandmother less than a week ago. You know, last week Tuesday just passed. You know, I had to watch it on this kiosk. My grandmother's funeral, my father's mother. You know, and I'm just really just seeking to get all this corruption out to the public. So they have I guess they have they specialize in stonewalling corruption in the DeKalb County Superior Court. So that's my plan, just to get it out to the public. Don't shit last forever. Tune in to Nelson Chet new YouTube channel, and you will see my video. Intend to prove it rain, featuring Muck shit, you know. And hopefully I'll be released from this bus and put him in soon, pretty soon, you know. Get back home to my kids, to my family. They miss me so much. Is there any more questions you would like to ask before we end this interview?